Good afternoon, one and all. I'm Harshveta, presenting on HDS Biopharma Limited versus the Controller of Patents and Design and another. The date of decision for this case was 30th of August 2022 in the Court of Justice Pratibha M. Singh, Delhi High Court, and the hearing has been done through hybrid mode. The appellant is Ireland-based company, and they filed their PCT national phase application in India on 10th of November 2017 with application number 2017-170-40270 titled Composition comprising 15-oxo EPA or 15-oxo DGLA and method of making and using it. Initially, the applicant filed the application with claim 1 to 26 with a priority date of 13th May 2015, which got published on 29th December 2017 in Weekly Journal under Section 11A of the Act. Then a request for examination, also known as RFE, under Section 11B of the Act was filed by the applicant on 13th May 2019. The appellant thereafter voluntarily amended the existing claims and introduced new claim 1 to 26. IPO New Delhi issued first examination report FER on 5th March 2020. First examination report had the following objections. Number one, all the claims 1 to 26 lacked inventive step. Number two, non-patentability under Section 3I. And number three, lack of clarity and consciousness under Section 10.5 and 10.4C of the Act. The applicant submitted response to FER on 8th of July 2020, in which the applicant cancelled claim 7 to 26. The IPO New Delhi then issued hearing notice on 25th November 2020, in which it objected non-patentability under Section 3D under the Patents Act for claim 1 and 4 of the application. Now, Section 3D talks about the invention which are not patentable if the mere invention is a new form of known substance or and does not result in enhancement of the known efficacy of the substance, or the mere discovery of any property or new use of known substance, or of the mere use of known process, machine, apparatus, unless it results or employs at least one new reactant. Appellant submitted written statement WS on 28th December 2020, amending its claim with only claim ranging from 1 to 4. After WS was filed, Learned Assistant Controller of Patents rejected the said patent application by the impugned order dated 13th January 21. Now, Ms. Mani, Learned Counselor of Appellant, submits that the appellant satisfied FER objections and new objections were raised in hearing notice under Section 3D. She also submits that the patent application was rejected on the ground of lack of inventive step under Section 21JA, in addition to Section 3D, and lack of clarity under Section 10.4C of the Act. Section 3D bars from patentability of new form of known substance, but the hearing notice never identified any known substance and left it to the appellant's deduction as to what is the known substance. Here, the appellant also referred to Fresenius Kavi's judgment, where Justice Pratibha Sridevan concluded that for the purpose of a Section 3D objection, that the one specific known substance is to be identified, and the manner in which the claim compounds are new forms ought to be mentioned by the Patent Office, even if it is not in detail, but in a brief manner. Now, Learned Controller had failed to identify the known substance in the hearing notice, and therefore the appellant was unable to respond clearly to the objection of the hearing notice, which in turn severely hampered the opportunity of the appellant to defend its patent application. So it was held in the court, in the Delhi High Court, that in the absence of proper identification of known substance in the hearing notice and lack of proper opportunity being offered to respond to the objection under Section 3D, the impugned order is not sustainable. And on top of that, Delhi High Court also said to afford a fair opportunity to the appellant the following directions were issued. Number one, the appellant shall file its response on the basis of identified known substance and the extract of the impugned order as set out above. In response, the appellant may also produce efficacy data and support its submission as to how Section 3D is not applicable for their invention. The second direction was the respondent shall file, the response shall be filed by the appellant within a period of 8 weeks, upon which a fresh hearing notice shall be granted on the issue of whether claim 1 to 4 are liable to be granted or not in view of the objection under Section 3D of the Act. Number 3, the controller is also permitted to consider, along with the objection of Section 3D, the objection relating to lack of inventive step, if any. In addition to that, Delhi High Court also perused claim 1 to 4 and said that the objection under Section 10(4)(c) and Section 10(5) of the Act would not arise in the present appeal. And Delhi High Court also gave learned counselor only 6 months to decide for the appeal. And the appeal is allowed in the above term. The impugned order is set aside. Nothing stated in the impugned order and in the present order would bind the controller on the merits of the objection, which are to be dealt with him under Section 3D or under Section 21JA of the Act. Thank you.